Good day, Crime Talk aficionados. We have another great show for you today. First, some new photographs released in the Bryan Kohberger case, a big ruling in the Gilgo Beach matter, I called it. We have an update on that David guy that spells his name with a 4. The dead woman found in the trunk of his car at a tow lot. Jury deliberations are done in the case of the man charged with attempting to assassinate Donald Trump. Diddy wants a minimal sentence. We have this day in legal history, our quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And make sure you check us out on any of your favorite podcasting apps as well. Before we get to the docket, let me remind you to do a couple of things. First, go to CrimeTalkSearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone in the United States that you desire. You're going to find out information that you thought you would never get. You're going to get phone numbers, emails, social media presence, maybe some sites that they didn't tell you that they were on. That's right. You're going to find out if they have a criminal history. Are they maybe a sex offender? Didn't tell you that. Maybe just getting to know you, right? Go to crimetalksearch.com. You're going to be happy that you did. Heck, it could even save your life. I think you'd be committing dating malpractice if you didn't check out that new date on crimetalksearch.com. And also, we told you about this. It's up on the website. There's a link below. You want the Crime Talk tag, keychain, bag tag. I'm going to put these all over my suitcase when I go to my son's wedding in Italy next week. So I'm going to say, yep, there's Crime Tag. I may take him to the wedding. I may hand them out as party gifts for everybody, right? No, just kidding. But you could. And guess what? They're popular. We're selling a ton of these. They are flying off the shelf. So if you want one, you better do it now. It's $5, ladies and gentlemen. And you can have yourself a Crime Talk keychain. Do it now. All right, let's go ahead and get to the docket for Tuesday, September 23rd, 2025, ladies and gentlemen. So, some new photographs released in the Kohberger matter. That's right. Police have disclosed a series of previously unreleased crime scene photos, and we got them here. Don't worry, nothing gory, from the residence where Bryan Kohberger is responsible for the murders of the 4 university students. Now, the Idaho State Police have made available 10 new images captured inside the residence where Kohberger fatally stabbed Madison Mogen, Kaylee Gonzalez, Zaina Kernodle, and Ethan Chapin using a K-bar knife. Now, these photographs depict various elements within the property, including overturned stools in the kitchen area, a potential imprint, residual items from a prior gathering, a vintage camera, a portable audio device, and a sliding glass door that may have served as the point of entry and exit for Bryan Kohberger. More than likely it was. Anyway, while these images don't contain visible bloodstains, unlike the previously released evidence that documented the graphic aftermath, they provide additional insight into the layout and the contents of the residence. Now, for those who maybe haven't been following the Bryan Kohberger case, back in July, he received 4 consecutive life sentences without the possibility of parole based upon his guilty plea to 4 counts of murder, as well as 1 count of burglary. And of course, he avoided the death penalty. Next on the docket, a big ruling in the Gilgo Beach case. And I hate to say I told you so, but I called it. So in a significant development in the Gilgo Beach murder case, the Suffolk County Judge Tim Mazzei, M-A-Z-Z-E-I, has ruled that prosecutors may introduce advanced DNA evidence against accused serial killer Rex Heuermann. Now, while consolidating the charges into a single trial for the death of 7 victims. Anyway, this outcome aligns precisely with my prior assessment of the proceedings and is typically the case in my analysis. As done by independent survey, indicates my accuracy rate is 98.6%. Take that to the bank. Anyway, the ruling represents a substantial advantage for the Suffolk County District Attorney, Ray Tierney, whose prosecution relies heavily on genetic material linking Heuermann to the crimes. Now, Tierney expressed firm confidence in the evidence, stating that he would not have pursued the case without it. Now, let's not forget about old Rex Heuermann, the 61-year-old architect facing allegations in the killing of Valerie Mack, Jessica Taylor, Megan Waterman, Melissa Bartholomew, Maureen Brainerd Barnes, Sandra Costilla, and Amber Lim Costello, whose remains were discovered along a remote section of Long Island between 1993 and 2010. The investigation gained momentum under former Suffolk County Police Commissioner Rodney Harrison, culminating in Heuermann's arrest back in July of 2023. Now, subsequent searches of Heuermann's residence in the Massapequa Park reportedly uncovered a detailed planning document, which prosecutors cite as evidence of premeditation, including reflection on past and potential future actions. Tierney highlighted this document as a key factor in the court's decision. Now, defense attorney Michael Brown contested the admissibility of the DNA evidence processed by Astra Labs, using innovative techniques for degraded samples, a method not previously found reliable in New York courts. But Brown urged that the laboratory lacks state licensing, potentially violates healthcare regulations, and advocated for separate trials for each of the victims to ensure fairness to his client. Despite these challenges, the judge upheld the evidence use following an earlier preliminary decision, and Brown maintained that his motions were grounded in legal principles, though the final determination rested obviously with the court. Now, prosecutors anticipate presenting testimony from over 100 witnesses from across 15 states, supported by more than 6.5 million documents and approximately 100 terabytes of data, reflecting the extensive 30-year investigation spanning multiple victims. Now, a guy by the name of Bob Macedonia, representing Heuermann's former spouse, Asa Elrup, noted that the prolonged proceedings have imposed significant hardships on Elrup and her family, delaying their ability to progress until resolution of these cases. Now, Heuermann remains in custody without bail as the case advances towards trial. Told you, ladies and gentlemen, I hate to say I told you so, but I knew it was coming in. All right, courts love this stuff. Had a case years ago. They couldn't figure out why these two kids died. They figured malnutrition. They brought in some lab that could say that they could tell when somebody had eaten and if there was deficiencies, and said, malnourishment based upon hair that was taken from the crime scene. Courts love that stuff. They eat it up. The juries love it because they think it's CSI. They're like, this is so breaking. And, if it's used repeatedly, it's usually pretty reliable, because let's face it, everyone is attacking it and they're coming up with their best arguments and they're getting experts to attack it. So if it's coming in, for the most part, you got to kind of do it. Now, be careful of all. Don't trust it completely, ladies and gentlemen. You can't. Errors can be made. Humans are involved in this process. And bottom line is, you got to trust the people that are doing it. People make mistakes, garbage in, garbage out. So the data is only as good as what is produced and put into the computer when they do the statistical analysis. But I think this is going to be a long guilty plea for Rex Heuermann. He can sit there, deny it. I get it. Go to trial, make the appellate record. You got nothing to lose. You're going to spend the rest of your life in prison. You might as well go to trial and enjoy wearing that suit one last time. Of course, we'll give him the presumption of innocence like we do everybody. Next, an update on the David guy that spells his name with a 4. So the investigation into the death of Celeste Rivas, a teenager reported missing back in May of 2024 at the young age of 13, has intensified following recent developments involving singer David Anthony Burke, professionally as D4VD. Police discovered Rivas's dismembered remains on September 8th of this year in the front trunk of an impounded Tesla Y registered to Mr. Burke. The vehicle had been abandoned near Dowie Place and Bluebird Avenue in Hollywood, in close proximity to a rental property where Burke had been residing. Then on September 17th, 2025, the Los Angeles Police Department executed a search warrant at the 4-bedroom Hollywood Hills residence leased for a paltry $20,000 per month by Burke's manager, Josh Marshall. The property, that was valued at $4.1 million and previously owned by the actress Halle Berry, yielded several items of evidentiary value, apparently, including a laptop, which are undergoing further analysis. Now, the LAPD has confirmed that the raid is linked to Rivas's disappearance and presumed homicide, though no charges have been filed and no individuals have publicly been identified. Yep, presumed as a homicide. Found in a front trunk of a car, dismembered. I'm going to go with homicide. I guess maybe there's a chance it was natural causes. Somebody freaked out, dismembered her, abuse of a corpse, right? But no, I'm going to go with murder. Now, we're not saying this Burke guy or David with a 4 did it, but you think it's kind of weird that his car was in an impound lot, didn't know where it was, didn't ask, didn't inquire. I think there's a reasonable questions. I'm not saying he did anything. Maybe somebody around him did something, but somebody put a dismembered body in his car. And I bet you he'd like to know who did it, don't you? I would. Now, the lease on this $20,000 a month rental property, isn't that what you all pay for your monthly rent? Anyway, that was initiated in February of 2024, coinciding with Rivas's initial reported absence from her family home in Lake Eleanor, was terminated shortly after the search of the residence. The property owner confirmed that Marshall requested to end the agreement, citing the ongoing circumstances, and has begun removing belongings from the home. The landlord, who had no prior knowledge of Burke's presence at the home, expressed disturbance over the events and noted that the neighborhood security features, which may provide surveillance footage to police investigators. Anyway, Rivas has briefly returned home after a February disappearance, but vanished again in May of 2024. Police indicate that her remains were severely decomposed, you think, suggesting she had been deceased for an extended period of time, possibly while still 14 years old. The Tesla was not reported stolen to the impoundment on September 6th, and the discovery occurred at a tow yard due to, a very odious odor coming from the front of the car. You know that's not good when somebody says, wow, that car that's sitting outside really stinks. I wonder what's in it. Anyway, police are examining the nature of any connection between Burke and Rivas, and sources have alleged an inappropriate relationship, potentially beginning with Miss Rivas, the age of 12, which claims that her family's disapproved, prompting her to leave home. Now, Rivas's brother stated she departed in May of 2024 to meet Burke for a movie and did not return, noting Burke's use of the same vehicle to drive her around. Social media images purportedly depicting the pair are under verification, and communication from Rivas to friends reportedly ceased in late July or early August of 2025. Now, Burke, who's now 20, which should be, more than the 4 years age difference, usually for what they refer to as sex assault on a child. Not saying he did anything, but, there's allegations that he was involved with her. 12 will get you life, Mr. Burke. Anyway, Mr. Burke was on tour at the time of the discovery and has since canceled remaining performances, including his international dates. His record label, Interscope Records, has postponed a planned deluxe album release, and a representative for Burke's indicated cooperation with police, and he has engaged legal counsel. The LAPD continues to pursue all leads in the case. There was a vigil held on September 22nd outside Rivas's family home, where community members came to honor her memory. A fundraiser has been established to cover funeral expenses, describing Rivas as the cherished family member and friend. The cause of death remains undetermined. Well, I'm going to go with murder, homicide. We're going to say homicide. Cause of death, we'll have to wait and see, right? Chopped up into little pieces, probably died before that. We'll have to wait and see. Next on the docket, the jury deliberations are done, and not after a long amount of time, in regards to the attempted assassination of Donald Trump. So, in a federal courtroom, a man acting as his own legal representative in proceedings related to the allegations of assassination attempt on Donald Trump at a golf facility in Florida last year asserted to the jury in his final presentation that he harbored no intention to cause harm to any person on that occasion. So I guess he admitted that he was there. Ryan Ruth emphasizes that it was difficult for him to accept that an offense had taken place, given that no shot was discharged. Oh, Gosh, this is what happens when you defend yourself. Anyway, he highlighted his visibility of Trump approaching the sixth hole and added that he could have targeted the confronting Secret Service agent if harm had been his objective. That's the old, if I really wanted to kill you, I could have killed you defense. Doesn't work, Mr. Ruth. Anyway, Mr. Ruth used 55 of his allocated 1 hour and 45 minutes for his final summation, whereas the prosecution nearly exhausted their designated period before the matter was handed over to the jury for consideration. Now, the judge, Judge Aileen Cannon, has previously cautioned Ruth against deviating from pertinent topics during his concluding remarks, prompting her to excuse the jury from the room on 2 occasions that morning to reiterate those directives. Now, according to the prosecution, Ruth had engaged in extended planning over several weeks prior to positioning a firearm through foliage where and when the Republican figure was engaged in golf on September 15th, 2024 at his West Palm Beach venue. The United States Attorney stated that unequivocally to the jurors that the evidence demonstrates beyond any reasonable doubt that Ryan Wesley Ruth sought the death of Donald Trump. Now, Ruth, who's 59, had entered a plea of not guilty to the accusations, including the attempted assassination of a prominent presidential contender, assault on federal law enforcement officials, and multiple infractions involving firearms. Now, on the preceding day, towards the end of the session, the judge advised Ruth that final argument must remain connected to the evidence and statements introduced during the trial, warning that non-compliance could result in the forfeiture of his remaining time. Now, although Ruth invoked the right to remain silent, the Fifth Amendment, gives you the right to refrain from providing testimony in his defense, the judge clarified that he could not employ his summation as a means to offer unsworn statements without facing cross-examination. Now, Ruth indicated comprehension, though he had received comparable guidance nearly 2 weeks prior for his initial address, which was terminated by the judge after just 10 minutes due to his total, complete, and utter disregard of the instructions given by the court. Now, Ruth concluded his defense presentation on the prior morning after examining only 3 witnesses, a specialist in firearms, and 2 individuals attesting to his character for approximately 3 hours in total. In comparison, the prosecution dedicated 7 days to interrogate 38 witnesses. The judge approved Ruth's application to proceed pro se following an evaluation in July because they thought he was crazy. They comped him. Anyway, established legal precedent from the United States Supreme Court affirms that a defendant may opt for his own self-representation if they demonstrate competence to forego professional legal assistance. Ruth's previous attorneys have remained available as advisory counsel throughout the proceedings, and testimony from a Secret Service agent described observing Ruth prior to Trump's appearance in the vicinity. Ruth directed his weapon towards the agent, who responded with gunfire, leading Ruth to abandon the firearm and escape without discharge. The police received assistance from an observer who reported seeing an individual departing the scene following the shots, and the observer was transported via law enforcement helicopter to an adjacent highway where Ruth was apprehended, and the observer was able to do a one-on-one show-up to verify that's the guy that did it. It's called a one-on-one show-up. This event occurred merely 9 weeks after Trump endured a separate assassination effort during a campaign event in Butler, Pennsylvania, where the assailant discharged 8 rounds, one of which slightly wounded President Trump's ear, before being neutralized by a Secret Service marksman up on that little rooftop. Anyway, Ruth, formerly employed in construction in North Carolina and most recently residing in Hawaii, portrayed himself as a leader in mercenary activities and had openly discussed hazardous and potentially aggressive intentions to involve himself in a global dispute. And guess what? The jury didn't take long to deliberate, found him guilty of all counts, whereupon he tried to stab himself in the throat with his pen. I guess like this. Didn't quite work because the 4 marshals dragged him to the ground, took him behind the magic door, handcuffed him, took him out of his suit, and brought him back in for the judge to explain that you've been found guilty, guilty, guilty on all charges. Sentencing is forthcoming. Never, ever represent yourself, ladies and gentlemen. Worst thing you can possibly do. You lose sight of what's going on when you represent yourself. You need to have an attorney do it. Tell you if you have a viable case, defense. And guess what? Just because you lose doesn't mean your attorney was ineffective. Sometimes you just got some really bad facts and they're protecting your rights. That's almost as ironic as, when you win a trial and then somebody wants to sue you. Ridiculous. But that's the world we live in. Next on the docket. Diddy wants a minimal sentence. That's right. Attorneys representing music executive Sean Combs, known professionally as Diddy Do It, aka Diddy, have petitioned a federal judge in New York to impose a sentence of no more than 14 months for the conviction on 2 charges involving interstate prostitution. Now, given that Combs has already been incarcerated for approximately 13 months, such a ruling would facilitate his prompt release. Now, this request was submitted in writing to the judge by his attorneys, who previously denied the judge previously denied a $50 million bail proposal, indicating reservations about granting Combs pretrial freedom. In their pleadings, the defense emphasized that Combs' prominence in industries such as music, fashion, spirits, media, and finance had been irreparably damaged, and that the consequences he has endured constitute sufficient penalty. The document also detailed the challenges Combs had faced during his detention, the adverse effects on his professional enterprises, and the rationale behind his rejection of a pretrial plea agreement offered by the prosecution. Now, Combs is scheduled for sentencing on October 3rd, following his July 25 conviction by a jury in Manhattan on violations of the Mann Act. Each count carries a potential maximum of 10 years imprisonment. However, he was acquitted of the more serious allegations, including racketeering, conspiracy, and sex trafficking, which could have resulted in a mandatory minimum of 15 years to life in prison. The defense counsel also highlighted in their pleadings the jury's acquittal on the more severe counts as a clear affirmation of Combs' innocence on those matters, urging the court to consider this in determining an appropriate sentence. They described his time in the high-security facility as transformative, noting that he has achieved sobriety after more than 2 decades of substance use and has productively engaged in self-improvement. Prosecutors who plan to submit their sentencing recommendations before the hearing have indicated an intent to advocate for a term significantly exceeding their initial estimate of 4 to 5 years. The defense characterized this stance as lacking proportionality. Regarding the repercussions beyond incarceration, the filing noted substantial disruptions to Combs' enterprises, including the termination of over 100 employees, many of whom have struggled to secure new employment due to their prior affiliations with Combs. His 7 children have experienced significant setbacks, such as forfeited opportunities in entertainment, fashion, and performance, compounded by their involvement in numerous civil lawsuits against Combs. Additional losses include the cancellation of the planned Hulu series featuring Combs and his family, his removal from leadership roles at charter schools he established in Harlem, the Bronx, and Connecticut, and the revocation of the honorary doctorate from Howard University, along with the return of his previous contributions to the institution. The attorneys described Combs' prison experience as arduous, including an encounter where another inmate confronted him with an improvised weapon over a seating dispute, which Combs resolved peacefully. He remains under continuous suicide monitoring, requiring frequent checks that interrupt sleep in an illuminated cell. Access to potable water is restricted, necessitating that he boil it for safety, and he resides in a communal quarters with limited privacy. Furthermore, Combs has not had exposure to fresh air or sunlight for nearly 13 months and suffers from an untreated knee injury causing mobility issues, while reports indicate occasional contamination in the provided meals at the prison. Now, the defense explained that Combs declined a pretrial plea offer, which would have entailed admitting guilt to offenses for which he was later acquitted, and a recommended sentence of at least 25 years, as it conflicted with his assertions of innocence. They portrayed his past conduct as influenced by chronic substance abuse amid a demanding celebrity existence without excusing it. The trial evidence included accounts from 2 former partners detailing coerced participation in extended sexual encounters involving third parties, often under the influence of substances, which Combs allegedly observed and recorded. The defense acknowledged instances of domestic violence, but maintained that the prosecuted charges were not substantiated. And now, reportedly in a more stable emotional state after initial periods of profound distress, Combs has initiated educational sessions for his fellow inmates on topics like business strategy, entrepreneurship, and self-advancement. His legal team expressed optimism that upon release, he could extend these efforts to broader correctional programs, focusing on family, commitments, and societal contributions as he prioritizes his reformed life. Now, I certainly hope all that is true. Now, I'll be the first to say, when those charges came out, I thought, ooh, that's serious. That's serious. Something's going to stick. And something did, but obviously the much more less severe charges. Now, we also watched as the case developed that what the prosecution had promised in some of their pleadings just wasn't exactly the way the evidence was coming out. So that's the way the system works. The government charged it. They made an allegation. The burden's on them to prove it. They couldn't. They got him to Mann Act. Flying prostitutes across state lines, ladies and gentlemen. Gee, I wonder if any other celebrity in the world has ever done that before for a big party or maybe big time business leader. Gee, I don't know. I wonder if there's been a couple. Anyway, Combs got on the radar. He got popped. He's got no criminal history. You would think a minimal sentence would more than likely be appropriate. The prosecution's going to ask for 5 or 6 years. They're going to look silly. And maybe the judge goes a little bit higher than the 14 to 15 months that Combs is asking for. But it's not going to be a lengthy sentence compared to what the government is asking for. We'll bring it to you on October 3rd. Next, this day in legal history, on September 23rd, 1901, Leon Czolgosz was put on trial for assassinating U.S. President William McKinley at the Pan American Exposition in Buffalo, New York. On this day in 2020, a Kentucky grand jury declines to charge officers with homicide in the death of Breonna Taylor, sparking some nationwide protests and discussions on police accountability and criminal justice reform. Our legal quote of the day has to do with a little more Supreme Court stuff, why it's kind of significant. Big ruling came out the other day, basically says, the president should be able to fire anybody he wants in any of these agencies. Otherwise, how is he going to implement his policies? So, legal quote of the day. I can't get alarmed when the Supreme Court overrules a prior decision, especially if it's 5-4. Who's to say that 5 men 10 years ago were right, whereas 5 men looking the other direction today are wrong? Harry Blackmun, April 20th, 1970. And finally, our dumb criminal of the day. Haven't we all been here? Let's listen. In a story worthy of a bad detective novel, a Key West, Florida resident allegedly turned her quiet neighborhood into a high-stakes standoff, wielding a .22 Magnum revolver and accusing locals of pilfering her cell phone, only for the police to discover that the gadget had been lounging safely in her own car the whole time. Yes, ladies and gentlemen, meet our dumb criminal of the day. Gail Stevenson, a 57-year-old from Florida, now faces a trio of felony charges following her Friday evening escapade. Police reports detail how officers uncovered both the supposedly vanished phone and the firearm she reportedly brandished, tucked away in her Ford Explorer and stashed near her residence as per the arrest affidavit. Now, under the misguided belief that a hitchhiker she kindly transported had made off with her phone, Stevenson reportedly escalated matters significantly. At least 2 neighbors recounted a hair-raising encounter. A 52-year-old gentleman claimed that she aimed the revolver squarely at his torso, while another described her pounding on the doors, convinced the elusive passenger was hiding inside. When the police arrived and Stevenson vehemently denied owning a gun or overlooking her phone in the car, insisting multiple times that they were welcome to inspect it, she unwittingly invited the search that sealed her fate. An officer's account in the report paints a comic scene upon opening the driver's door. The stolen phone was spotted casually sprawled on the floorboards. Venturing further, a revolver case peeked out from beneath the folded rear seats. Pressed about the absent weapon, Stevenson cleverly suggested her spouse may have whisked it away to Georgia, maintaining her firearm-free status. Undeterred, police scoured the area and allegedly unearthed a thunderstruck .22 Magnum loaded with 2 rounds and accompanied by a baggie of 4 extras, all concealed in a regal purple Crown Royal pouch behind a trash bin on her fenced property. One might say she hid it with the subtlety of a squirrel burying nuts in plain sight. Adding to the evening's absurdity, Stevenson eluded a potent aroma of spirits and confessed to indulging in several libations that evening. Amid the interrogation, dispatch lit it up with reports of a blonde woman in a white SUV with an odd license plate, honking incessantly, hammering on doors, and menacing occupants with tales of robbery. The male victim elaborated that the persistent horn blasts drew him outdoors, flashlight in hand, to offer aid, only to be greeted by the business end of a pistol. He inched closer to confirm the threat, prompting Stevenson to allegedly snatch up the gun, bolt from the vehicle, and vanished into the night like a startled cat. Meanwhile, the female neighbor wisely opted for door-ignoring tactics, admitting she had no clue who the frantic visitor was and chose, well, not to engage. Stevenson was promptly detained at the Monroe County Jail, facing counts of aggravated assault with a deadly weapon, armed trespassing, and tampering with evidence. Her court debut is slated for October 10th. Plenty of time to reflect on the perils of misplaced phones and misplaced trust. So, Miss Stevenson, you are our dumb criminal of the day. Congratulations, you made it. Dum, dum, dum. All right, ladies and gentlemen, that's all we have for tonight. Thanks for watching. We'll see you next time. And remember, the Constitution matters.